All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Pierre Bergeron presiding, is now in session. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. We have two cases to be argued this morning. The first is State v. Lattimore. The second is Lambert v. UP Cincinnati. If counsel could introduce themselves and indicate your readiness to proceed.
Good morning, Your Honor. Krista Gieseke on behalf of Mr. Lattimore. I'm ready to proceed.
Okay.
Good morning, ladies and gentlemen. Susan Zurfas on behalf of the City of Cincinnati. Will prepare as well.
Okay. And the second case.
Austin King on behalf of plaintiff appellant, Mr. Roger Lambert.
Okay.
Jim Gordon on behalf of Appellee of Cincinnati Race Court.
Okay. Thank you very much. All right. Ms. Gieseke, you may approach and let us know how much time you'd like for rebuttal.
I would like to reserve 3 minutes, Your Honor.
3 minutes. Very
Thank
well.
you. May it please the Court, Ms. Zurfas? So we have a sole assignment of error today arguing that Mr. Lattimore's OVI conviction is not supported by the evidence. And our standard under this court's Baxt case cited in our brief is whether the evidence supports that he was appreciably impaired. So here, the trooper testified he activated his cruiser cam when he saw the vehicle straddle 2 lanes. While driving between 2 lanes may give cause to stop a vehicle, we argue there must be additional indicia of impairment to support the conviction. So I just want to hit a few of the factors that support that there was not sufficient indicia of impairment. And the first is the vehicle alignment. This was an 83 Buick, so by now that's a classic car, even though it feels like 83 was like 20 years ago. That's a classic car, and they often have, mechanical issues. So Mr. Lattimore had had this car for just 2 months. Out of that 1 month, it was away being overhauled, the interior. He had not touched the engine or the mechanics of the car yet. He had only driven the vehicle 2 or 3 times and never at high speeds. And, cars often operate a little differently at high speeds, especially old cars. So he also presented a video at trial that showed that the steering wheel was straight, but the wheels were not aligned when he showed the wheels. So that would account for the car drifting a bit, especially at high speeds. So the trooper admitted there was nothing unusual about how Mr. Lattimore pulled over. He didn't notice anything unusual about Mr. Lattimore's demeanor when he first made contact. This stands in contrast to people who were falling asleep, fumbling through their wallet, or behaving peculiarly or aggressively. And regarding the...
But what about the fact that he did smell alcohol and your client had red, glassy, bloodshot eyes? So there were some indicia there.
Right.
And then he gave him the HGN test and saw, the requisite clues for intoxication.
Right, Your Honor. So regarding we would admit that the marked lanes violation gets him pulled over. Mm-hmm. And then the odor of alcohol and the red eyes. When you look at the rest of the record, though, we would say that those two were sort of disputable. Maybe not the existence, but the reasons were disputable. The odor, the trooper, it was kind of odd. He testified a number of times referencing that odor on direct, but they didn't attribute a level, strong, mild, moderate, weak. So
he never said it, strong, mild, moderate.
He did not until defense counsel wrongly summarized on cross. He said, you said it was strong. And when I went back and looked at his direct, he never said strong. He just said odor.
Okay.
And I believe the case law says, that kind of weakens that factor when the officer doesn't attribute a level. It makes it harder to assess the credibility of that factor. And, as you know, we probably say this in every brief, driving after 1 drink is not illegal. Driving, impaired is.
But your client testified he had no drinks, correct?
He did.
Okay.
He did. And then the red eyes, he was at this car show all day in the hot sun of July, from like 9 a.m. on, trying to showcase this car to sell it. So, we argue that could account for the fatigue from that all day long. It was late at night by the time he got pulled over. That could account for the red eyes. And then, the HGN...
Just on that, though,
Sure.
This is a situation where your client did testify.
Correct.
Did he address the red eyes in his testimony, or are you just saying that maybe it could be from the heat?
It could be. Like, on cross, that is how counsel chose to draw out alternate reasons. and I think the trooper at first might have been reticent to say, yeah, it could have been that. But then he acquiesced and said, yes, it could have been. And there was a lot of testimony on cross about he didn't know how things were normally for this particular person. You know,
Yeah, but did your client testify about having any kind of eye irritation or anything?
No, you're correct, no. And then one more reference to the trooper's reticence about, then I'll get back to the HGN. You know, one classic sign of being impaired is slurred speech. And what we would really emphasize with this whole case is just the video. You know, if you actually watch the video, he does not appear impaired, I think, whatsoever. You know, he doesn't have slurred speech, and yet the officer didn't want to say that. He just kept saying, I don't know. So, you know, I'm not sure of the reasoning for that, but if you just watch the video, he walks normally, he talks normally. You know, there was no like unsteady gait or anything like that that showed he was appreciably impaired. And even though when there's clashing testimony or clashing evidence in these cases, often video evidence is kind of a good tiebreaker. So we would argue that the video is important in this case. And then regarding the HGN, that's the last thing I will just go over really quickly. I know that this court said in the China Hamilton case that the field tests do not have to be conducted on camera. And we're not arguing, we're not trying to change that. It's just that when they are off camera and the officers can swivel their cameras, it makes them hard for this court to assess if it was done right. So we would just say it's not a due process argument we're making, just that it's one additional factor, and that also there was no testimony, and I think it was the 11th District in the Osborne case noted that NHTSA is not, you know, does not carry the force of law. So I think they tried to elicit testimony that the exhibition of clues necessitates a finding of impairment, and I don't think we can actually extrapolate that from the NHTSA. In fact, we don't know if you need all 3 field sobriety tests to get that finding. We don't have enough evidence on this record to say that.
Was there any argument that the HGN was not done correctly? I mean, was this what the officer was crossed on?
I think he did cross him on it, and I think that he got to. I think on cross, they went more to the number of clues. But I think he did elicit testimony about you can swivel your camera, right? He did talk about how it wasn't done on camera.
Not that, I mean, but was there questions about, did the officer admit that he did anything incorrectly in performing the test?
I don't believe so.
Okay.
Yeah.
Yeah, because we just had a case, I don't remember if it was last week or the week before, where the trial court granted the suppression motion, and it was the state's appeal, and part of the basis was the officer did not perform the HGN test properly, and that was the key indicator for which the officer cited the particular defendant. So I think there's a distinction, and it's really not for us to evaluate that. It's really for the trial court to evaluate, you know, is there evidence that the test was not performed appropriately? Right,
and there's 2 things with that in this case that make this case a little different. Is one, the 451119A violation, the impaired violation was not premised upon the test because he did cut them off after the HGN. So the HGN, I guess, is one part of the calculus, but not entirely. And then the other problem is that we would argue that the tests are more on point for a suppression hearing, and that they don't control this court's analysis, A, because all 3 weren't conducted, but B, that we're not at that phase of the case. We're really just assessing probable cause to arrest for OVI. So that when it's the state's appeal, the tests being performed improperly, that is the central inquiry at a suppression hearing, but not at this stage. So if there are no further questions?
I just have a question for you. My recollection is you talked about the NHTSA test, and my foggy recollection is those tests are indicative or indicia of impairment. Am I correct in that? You said it's not the law, and I agree with that, but when you do those various tests, my recollection is that is indicia of an impairment.
And admittedly, I didn't do the legal research on this part, but the state did elicit testimony from the trooper from his understanding of the NHTSA manual that exhibiting clues on the tests correlated to a blood alcohol level of above 0.08. And then the problem with that is that and I don't recall if this came out on cross or we just said this, observed this in our brief, but we don't know whether, we don't have the manual in front of us, it's probably this big. We don't know if you need all 3 tests to get to that, and they didn't do all 3 tests, so the answer is I'm not sure.
Okay.
Yeah, but
Well,
I don't know if you need more than 1.
I have a follow-up on the question about swiveling the camera, because I recall the earlier opinion. And and I watched the video, but I don't recall, was that conducted on I-75 southbound, or was it conducted somewhere else? The HGN test, what I'm asking about.
It was off to the side. I think they were on 75 South.
Okay,
I'm pretty sure you're right.
all right, okay,
Okay.
thank you.
If there are no further questions, I'll reserve the remainder of my time.
Great, thank you.
Thank you.
Ms. Rufus?
Thank you, sir. I'd like to reserve 2 minutes, please, for rebuttal. May it
Well,
please the court?
before you go, I'm sorry you don't get rebuttal.
I don't give rebuttal?
I'm the only one that gives
I'm not gonna
rebuttal.
reserve time. Can I
You don't
please?
get
Judge Winkler tries to give rebuttal to athletes every now and then,
It's
but
okay. I'm following the Winkler rule.
Yeah, we'll change the rules
Can we? For me, thank you.
today.
May it please the court, Ms. Gieske. As Ms. Gieske indicated, we're here on a sole assignment of error. However, that sole assignment of error is broken down into 2 distinct legal parts, sufficiency and manifest weight. Starting just with sufficiency, that's the part where this court looks at the evidence itself, looks at the reasonable inferences that can be drawn from that evidence, and then views that in the light most favorable to the prosecution. The evidence in this case that was presented was essentially that the trooper, who had more than 2 years of road experience and more than 70 to 80 OVI arrests in that time, was traveling on I-75 on July 4th, 2021. While he was traveling on I-75, he observed this vehicle that was really struggling to maintain its lane. And in fact, once his camera came on, we see this vehicle weaving within its lane. We see it straddling 2 lines. That in and of itself, while also reasonable suspicion to execute a traffic stop, is also some indicia of impairment. We presume, first of all, that drivers are driving roadworthy cars. We presume that if they're driving an unroadworthy car, they're going to keep it off of a freeway. We presume that if you're on the freeway, you're maintaining your lane, especially during the traffic that might be on I-71 and I-75, because those are main arteries into and out of Cincinnati. We presume that you're going to maintain your lane. If you're not maintaining your lane, it's fair that that's an indicia that you are impaired in addition to the roadworthiness of this car. Appellant focused a little bit on what was testified to by the defendant with regard to why that car was not roadworthy.
And what did the trial court make specific credibility findings here?
Not that I recall as far as credibility. However, it seemed clear from the record that the trial judge did discount particularly 2 aspects of defendant's testimony. One was the roadworthiness of the car, and the other one was whether or not he had consumed alcohol during the lengthy period of time he had been at this car show. One of the other indicia of impairment that the trooper testified to, while he did not initially indicate that whether the volume of alcohol that he could smell was weak, strong, or moderate, what he did say was he approached the vehicle to the passenger side and he smelled an odor of alcohol at that time. There were no other passengers in that vehicle, only the driver. In order for the odor of alcohol to project from the driver's seat to the passenger's window, I think that it is a reasonable inference for this court to make that that odor of alcohol was strong, that the defendant at that time smelled strongly of alcohol. So we have at that point at least 2 indicia of impairment to support whether or not the evidence was sufficient.
Well, you know, we got in this debate in another case, again, it was a couple of weeks
Certainly.
ago, about the odor of alcohol. Like, does and I guess I just don't understand, like, does the fact that you smell alcohol, you know, it's a powerful odor, does that indicate that you've had multiple drinks, or does it just indicate you've had a drink recently? Because I'm not sure the physics of that in terms of how we're supposed to gauge what that means.
I certainly understand that, and I think in this case, what you're doing is you're viewing it on a continuum of whether or not there were indicia of impairment. So I think the question is not how do we determine, do we use the odor of alcohol to determine level of impairment, but in this case, really the standard is, was there indicia of intoxication? And in particular, looking at State v. Hamilton, the state does not have to prove an alcohol level, so it doesn't really matter whether it was a strong odor or a weak odor as far as what that interprets to as BAC. But we have to prove that he consumed alcohol. Well, we have the odor of alcohol. There was alcohol consumption as an indicia of impairment, and that consumption adversely and appreciably impaired his actions or mental processes and deprived him of that clearness of intellect and control of himself which he would otherwise have had. Going on to State v. Panzica, FSTs are also not required. And in Panzica, we were dealing with a refusal, I believe, of all FSTs. In this case, the defendant refused FSTs after the HGN. He consented only to the HGN. And I heard your question with regard to the HGN and a little bit of colloquy with regard to how does the HGN factor into impairment? Well, the NHTSA manual, as well as all of the medical testimony and expert testimony that's been presented over the years on that is, oh gosh, sometime in the 1990s when we decided we were reducing the legal limit from 0.10 to 0.08, the question was, what can we look at in the body? What's the body doing to say that this is enough for us to get to the point of having probable cause to request the test? And what they were finding was, if you had all 6 clues on the HGN, there's a pretty good medical possibility that you are going to test above the legal limit, within that range of 0.08 or greater. And in this case, we had that. We had a trooper who testified. The HGN was never called into question at any point in time. There was never a suppression motion on the HGN, whether it was properly done or not. The fact that he didn't swivel his camera does not lend one way or the other to the indicia of impairment.
I frankly don't even know how you would be able to capture the HGN clues even if they did swivel their camera.
The camera
Because you're looking at the eyeball, right?
It doesn't pick up close enough. You would have to, even on body cam, it's very difficult when you're right up close because you're not looking eye-to-eye level at the body cam. The body cam is looking from a different level, and you're not necessarily going to see the bloodshot, glassy eyes, which again was another indicia of impairment to which the trooper testified. So at that point, we've got impaired driving times 2, struggling to keep it between the lines, weaving within the lane. He smelled of alcohol, which was detectable across the vehicle. He had red, glassy, and bloodshot eyes. And there was no evidence whatsoever to dispute those clear indicia of impairment. And under Panzica, that's sufficient for sufficiency of the evidence. Panzica and Hamilton. For sufficiency of the evidence, I think that the court must find for the state. With regard to manifest weight, it's a little bit different with manifest weight. With manifest weight, you're really sitting in as if you're trier of fact. You have the opportunity now to substitute your judgment for the judgment of the trial court. But in that case, there are 3 factors that make this not a loose standard to overcome as far as review. You have to review the entire record, again, weigh the evidence and all reasonable inferences. And again, the inferences before the court are that there was impairment. I think that that's what's inferred by all of this evidence. Consider the credibility of the witnesses. You've got the defendant who did testify on his behalf. So the defendant testified. He gave statements with regard to this vehicle. He's out late at night. He'd been at a car show for several hours. He didn't have anything to drink. However, you've got the trooper also who is trained to identify indicia of impairment and said, I could smell alcohol from across the car. And I think at that point, that calls the defendant's testimony itself into question, because now we're not even talking about whether it was a weak odor of alcohol. Yeah, I had a beer at 2 o'clock in the afternoon in the heat of the day at this car show, or I just drank 2 shots before I left the car show and I have a strong odor of alcohol, but I haven't had substantial substantial intake, consumption of alcohol. Now, he's saying, I didn't have anything to drink all day long, and yet there is an odor of alcohol. This is not this substantial period of time, given the activities that he testified to that day. It's not one of those things, well, it could have been leftover odor from last night, because we're like 12 hours of activity that he testified he had engaged in during the course of that day. So the question is, did the trial court clearly lose its way and create a manifest miscarriage of justice such that the conviction must be reversed? And I think that when you look at the entire record, the record in its entirety here, I don't think that we can come to the point where you say the trier of fact clearly lost its way. The judge was in the best position to determine the credibility of the witnesses, essentially the trooper and the defendant, and the defendant has skin in the game here. He has a reason to indicate to the court that he was not drinking and driving. He doesn't want an OVI conviction. It's understandable. And I think that that's one of those factors that plays into credibility. And while I don't believe that the judge addressed, I found you incredible, I think that the judge's decision in this case was such that she clearly found that the defendant's testimony was not credible, that it was incredible at that point in time. In State v. Martin, the reversal of a conviction and grant of a new trial should only be done in exceptional cases in which the evidence weighs heavily against the conviction. In this case, Your Honors, I don't believe that you can say that the evidence weighs heavily against this conviction. And for that, Your Honors, I respectfully request that you affirm the conviction in this case. Are there any questions?
Great. Thank you very much.
Thank you.
Ms. Giese, you have 5 minutes.
Okay, thank you.
Ms. Giske, was there any evidence of the alignment problem with the car besides your client's testimony?
His video. So for vehicle alignment, if the wheel is straight, the tires should both be straight. If it's a front-wheel drive, the front tires.
Okay.
So if you look at his video, that's why he went and filmed it, and he had the steering wheel fixed, and then the tires were not aligned.
Okay.
If you look at the video.
Gotcha.
So one thing that I will concede is that, sufficiency, I will never forget one case that my colleague argued, and Judge Zayas said, why didn't you argue sufficiency? Only wait. And from then on, I will never not argue, put that in my assignment of error. But it is for issue preservation, so we will concede that this is a wait case. So the trooper had, I think counsel said over 2 years of experience, and when I call someone a rookie, I don't take that lightly because I have the utmost respect for police officers. And I think I Googled it, and it's 2 years of experience or more, and you're out of the rookie phase. So I think he didn't have, not nearly as much as some of the officers that we see in a lot of our cases. So he was, he had some experience. He was still earning his wings or whatever. So we would concede that there's enough to pull this car over. When you see a car commit a marked lanes violation, sure, enough to pull it over, even enough to investigate further. But the real crux of the case is, was there enough to arrest for OBI? And Judge Bergeron, in response to your question, there were no specific credibility findings. The roadworthiness of the car, I think counsel said that was, the trial court discounted that. But again, see the video. It's kind of uncontrovertible. If the tire's not straight, the car's alignment is off. So I don't know if that renders it unroadworthy. That's really a civil term, I guess. But, there is evidence to that effect. And then
that is evidence that your client put together for the purposes of the proceeding. It's not like some independent mechanic or something like that. So, as far as the judge, if the judge didn't believe your client,
But you can't. Sorry.
No, I'm just saying that, if she found your client not credible, she may not find the evidence that he produced credible.
Right, but I'm not sure how, how many over 1,000-pound rubber vehicles weigh. You can't manufacture one wheel going one way and one wheel being turned another, tires. You can't do that. I guess someone who's computer savvy could doctor a video, but I don't think that's the average bearer. Counsel argued the state does not have to prove the level, and under the A charge, they don't. That's under the per se violations, but they do have to prove appreciable impairment. And Judge Bergeron, to your question, driving after a drink, driving with some smell, alcohol is not illegal. As driving impaired is illegal. And the problem with counsel's argument about the 6 clues on the HGN and kind of the evolution of these tests is that saying that the 6 clues equal impairment, that argument and that evidence was not elicited at trial. So it would be kind of, that would be a great thing for the state to develop in one of these cases, I agree, but it wasn't in this case. And then the last thing that I would just emphasize is that, we have videos in this case. Even aside from the defendant's video, the dash cam video, the average person can watch it and see how Mr. Latimer was acting, and he did not act drunk. As far as the clues and the capturing the test on camera, it's not per se for us to look and see if the subject is exhibiting clues. We're watching to see if the trooper or the officer is conducting these tests. We can read the NHTSA manual. We can see if he did hold the stylus however many inches away and do those. And we can't do that when the tests are off camera. Again, it's not dispositive, just one more factor in the calculus of probable cause to support the arrest. So if there are no further questions, we would just ask this court to reverse and remand for a new trial.
Great.
Thank you.
Thank you very much. Thank you both for your arguments this morning. The case will be submitted and we'll get out a timely written decision. Hope you both have a great day.
Thank you.
All right, the next case is Lambert versus UP Cincinnati. Mr. Lapuma, you may come forward and
One second.
absolutely.
I'll reserve 4 minutes.
4 minutes, very well. You may proceed when you're ready.
Mr. Gordon, may it please the court. Good morning. The trial court erred when it granted summary judgment in favor of the birdcage, as there were genuine issues of material fact across 3 main areas. The first is the very nature of the hazard itself. The second is that violations of the Ohio Building Code and local ordinances create fact issues. And third, revolving circumstances, attendant circumstances, create fact issues. First and perhaps foremost is the assessment of the hazard at play today. As the court's recent decision in McLean v. the Drinkery makes clear, while it's true that the open and obvious doctrine is a matter of law, each and every analysis, including the hazard being latent or not, is fact specific. In viewing the facts in a light most favorable, as the trial court should have done, this hazard cannot be said to be open and obvious by its very nature, creating a warning for Roger.
Well, then what's a establishment such as the bar supposed to do if that's not open and obvious?
Absolutely. What it did in other situations where a hazard was not open and obvious. And it's twofold, Your Honor. First, legally, if we look to the Supreme Court holding in Jackson v. Kings Island, proprietors or occupiers of land are in the best position to understand the dangers that may be on their property. Further, if we look at Beck v. Total Crossing, we know that when a property owner is aware of a hazard that it should warn of, it has a duty to do so. In this case, we do know that the birdcage was aware of this threshold of 2 to 3 inches because the testimony of their own general manager characterized it as too steep. In other areas of the bar, which you can see as part of the summary judgment MIO, the photographs of 3A through 3K show that in other areas of the bar, there was fluorescent tape, there was markings, there was indicia that there was some sort of hazard that was there.
What do we do with the fact that your client was a regular, apparently, at this bar, and even on that particular day had gone across this threshold several times? I mean, how does that come in? Because I think trial court really relied on that in determining the hazard was open and obvious.
Yes, first of all, they did, Your Honor, and two things. That characterization was a characterization by defense. Roger had testified he'd been there on a few occasions previously. Discounting it being irregular or not, the actual standard of law is that prior usage should not impute knowledge about a hazard unless the usage of that area was essential to navigating around it. And here's what I mean. If we look at the case of Hall v. Penoyer, in that case, it set that standard and talks about that. Specifically,
But I thought he testified to that he had gone out on that patio before the night in question. So it would have been essential to cross over that step, right?
the difference is the acknowledgement that the hazard was there with actual knowledge and using around it. For instance, let's
Well,
say...
I mean, he stepped over it.
Absolutely. But he did not change his gait in a way that would recognize that the hazard existed, which brings the court's attention to what happened in Asher v. Glenway Real Estate, a recent First District case where the exact same principle was asserted.
Except for I was on that panel, and if I recall, the situation in that case where the door swung over the ledge, I thought that the testimony was that she had never opened the door herself before, so she didn't appreciate the danger, which is a little different than what we have here.
Sure, but if we turn back to knowledge, that's correct. There was
Right.
testimony that said she'd used it 3 prior occasions. However, she, the actual victim in that case, stated that someone else had opened this door that was wider than a landing that caused her to fall. That's true, but if we go back to that same argument that was asserted here, that she could see the door, she as a person should have recognized whether or not she opened it personally or not, she had prior usage with that doorway. Similarly, it is true, and we don't contest that Roger had walked past this threshold that was 2 to 3 inches high, black, unmarked, unlit, with no ramp on prior occasions. What he also testified to is that when asked point blank by Mr. Gordon, were you aware that that threshold between the doorway and the platform was not flush, he responded unequivocally no. And the reason why it's analogous to Asher v. Glenway is because he did not have actual knowledge nor made any adjustment. In that case, what was essential to ask was not whether or not it could be seen. It was, and I will quote what actual was said in that decision, was it visible or apparent upon first glance?
What do we do with the fact that he was drinking throughout this? Because, like, your ability to perceive a step may be different if you're completely sober versus having consumed several drinks.
All 2 things, Your Honor. To your point, if that goes to duty, then it should cut in Roger's favor. Using the same case law from Asher, talking about how each hazard and the assessment is contingent upon the totality of the circumstances, this is a bar. It serves patrons drinks. They have duties to ensure that the persons they are serving drinks to are protected. Now, in terms of a legal component, this is about the hazard itself. That was mentioned here and there. It's also uncontested that Roger was drinking that night and testified to having 3 glasses of wine over a period of time. However, in terms of assessing open and obvious nature, his own conduct is immaterial in assessing whether or not this hazard was latent or open and obvious in serving as notice itself.
Let me ask you about, I'm sorry.
Go ahead.
All right. Throughout the brief, it refers to the place where Mr. Lambert tripped as being dark and black, but now I'm looking at the photograph at page 4 of your brief, and it looks like there's a metal threshold or something there. Is that a subsequent remedial measure, or is that how it appeared on the night in question?
Sure. Appellant will say that that's admissible other ways, but definitionally, those were subsequent remedial measures taken after. So
You
prior
answered
to
my
that,
question.
as you'll see, which is the exact point about the duty to warn, prior to that, Your Honor, there was no ramp, there was no marking, there was no tape. All that existed was a 2 to 3 inch gap. And that is important, too, when you look at case law of Cash v. Kimball and Kimball v. Cincinnati, This was around the area where this wasn't just a negligible difference that should not have been unreasonably dangerous, but it wasn't a stair or a step in the traditional sense, which is the second part of this. There were tenable violations of both the building code that create fact issues.
Well, yeah, let's go to that for a second, because like to constitute negligence per se, it usually needs to be something like this step must be 4 inches in height, and you've got one that's 5 inches or 6 inches or something like that. And as I read the provisions that are cited in your brief, like they're just kind of general standards about like, you know, make sure things are safe. So like what specific provision are you saying this step violated?
Sure. The one cited in the brief, 1119-033, 1119-0702, 1119-0492, and 1601-11C. To your point, Your Honor, about them not being specific enough in terms of the abstract nature, it's true recently that in that same Asher decision, the court assessed one of the asserted violations here with a code, and to your point, said this was too general. However, the others are more specific, and furthermore, as appellant made clear, the legislature was very clear about
Which is the one that's most specific that you say there's a clear per se violation for?
1119-0702, means of egress. A safe, continuous, and unobstructed means of egress shall be provided from the interior of a structure to a public way. That is clear and definitive. There should not be any sort of obstruction in the way.
So is a step, are you saying a stair or a step down would be an obstruction?
I would say a stair or step is distinguishable. This was not a stair or a step. This was a riser, or using defendant's own assertion, a threshold. That was an obstruction. If it was flush to the platform, there would not have been an obstruction. Furthermore, under Chambers v. St. Mary, once that tenable code is asserted, the determination of whether or not it was an obstruction is for the jury to determine. And when the trial court deviated from that, they usurped the role of the jury and took Rogers' day in court away in determining whether or not there were tenable violations with specific codes that were asserted, as well as Ohio Building Code. Now, while it's true, like the Birdcage has asserted, negligence per se obviates the open and obvious doctrine. The building code does not operate the same way. However, if there are violations of the building code, that can absolutely serve as indicium of negligence, even if the hazard was open and obvious. The First District opinion of Christian v. Don van Vanderhauer, Marketing and Catering, makes this clear, that someone, similarly, a delivery man, had been there many times before, was walking up with paper up a ramp, tripped on the 6th or 7th step, and was harmed. It was open and obvious. He had been there many more times than Roger and could not even articulate what caused him to fall. However, the First District viewed the Ohio Building Code violation as creating a genuine issue of material fact, and therefore summary judgment was not appropriate. We're not asking—
Mr. LaPuma, you're at your time if you want to reserve for.
Yes, Your Honor. Real quickly, going down to 3, touching upon attendant circumstances which are nebulous in their definition. There are many ways to assess the totality of those. We assert that based on the fact that a matter of circumstances is detailed, dark, was holding on to multiple objects and walking into a lit interior, create those. As I'm out of time, we respectfully request that the First District reverse the trial court's decision and allow Roger to proceed to a jury trial. Thank you.
Thank you. Mr. Gordon?
Good morning to the Honorable Court. Mr. LaPuma indicated in response to the court's question regarding the fact that Mr. Lambert had come and gone, both before this evening in the fall and on this evening in the fall, and he said he didn't change his gait. Commonsensically, I think I understand what counsel means, meaning on the previous occasions, however many of them there were, whatever the lighting might have been like on those other occasions, Mr. Lambert must have gotten lucky, seems to be what counsel is suggesting. The problem with that is there is absolutely no evidence that that's the case. There's no evidence that Mr. Lambert's gate just luckily avoided this very common threshold at this point of entry or egress. That's just a guess. It's an assumption. It's not even an inference. It's not based on anything.
Well, but I think as I look at this, I mean, tell me why this isn't a question of fact in terms of, does it matter how many times he went there? Like, if he had only gone outside once versus however many times he did, like, where do we draw the line between saying, like, this we can decide as a matter of law versus this needs to go to the jury?
Is what an issue of fact, Your Honor?
The whole dispute about whether or not this was open and obvious and whether he should have appreciated it based on his prior use of it.
I think we have to go to the record as it stood at the time of summary judgment, and we have to look at that and ask ourselves, does that evidence indicate openness and obviousness? And I think one of the challenges here is, and this wasn't the thrust, it's sort of an underlying issue always, is why did Mr. Lambert fall? Like, if we start there, what caused him to fall? The evidence of that is really, it's incompetent, frankly. Mr. Lambert does not know what foot caught on what. He came back several days later. He looked at the doorway. He found something. He said it must have been that.
Well, I don't think that's necessarily uncommon in like trip and fall cases because, a lot of times you're obviously not aware of what happens until you're on the floor. So I don't ascribe as much significance to that. But I think kind of getting back to my question, like, if he'd only been out there once, like, would that be enough to say he knew it was open and obvious and therefore the trial court should decide this is a matter of law? Like, what is the threshold to take this away from the
Sure,
jury?
I think we would go back to an objective analysis. I don't think we look specifically at what Mr. Lambert says. I mean, obviously, any plaintiff can come and say, hey, I didn't know it was there subjectively, whatever it may be. Maybe something we all look at and say, clearly, objectively, anybody paying a lick of attention would have known it was there. And again, I think here there were no facts developed. There's commentary about it being, the time of evening. There's commentary about there being no light specifically projecting on this area. There's absolutely no evidence as to what the actual appearance of the area was when Mr. Lambert was walking back into the bar. Everything is incredibly vague.
It was nighttime, right?
It was nighttime, yes,
So
Your Honor.
it was dark
It's dark outside.
and it was
yes.
raining outside.
There was, best evidence is there was a light rain. Yes.
Okay, all right.
So it was dark outside. It was nighttime. There were lights around.
So your argument is that even if this would have been the very first time that he ever stepped through this threshold, that it was still open and obvious. We don't even have to rely on the fact that he had been across multiple times.
Well, I think that it's highly persuasive and clear that based on the fact that Mr. Lambert had been in and out multiple times that evening, in and out multiple times before, that Mr. Lambert would have known what the general configuration of that basic doorway was. So that is highly relevant, Your Honor. The idea that somehow that the condition of that threshold, and I don't want to even call it a hazard, it was simply a doorway like we see every day. The idea that that was somehow concealed when it would have been open and obvious, if the argument is, look, it would have been open and obvious during the daytime, but because it was nighttime, it wasn't open and obvious anymore. If that's the argument, than vague references to it was dark outside, or there wasn't a light projected directly on it, or it wasn't painted yellow, for goodness sakes. It's like, well, how dark was it? Was it truly not visible based on the darkness? There's absolutely no testimony.
What about Mr. LaPuma's point that because this is a bar and you're going to have people who may not have all of their immediate faculties with them as they're coming in and out, that the bar should have taken some additional steps to make, even if everything you're saying is accurate, that they should have taken some additional steps to really make sure people who might not be fully with it don't trip.
I think that's, Your Honor, I think that is something that if we were talking over a beer, we could say, boy, wouldn't it be nice? But the fact is, that's not the legal standard. The legal standard isn't, what could have, in hindsight or in general terms, made something safer. And so, again, if the argument is, would it have been safer if it had bells, whistles, lights, and sirens? The answer is, well, yeah, probably would have been. It would have drawn attention to it. But that's not the legal standard. And Your Honor's exactly correct. These code provisions are so general that they don't specify any particular duty. So we know that the duty can't come from there.
Let me ask you a question about
Yes,
this, sir. I know appellant counsel indicated that he believed that the City Municipal Code Section 119-7-2 means of egress was controlling here, or at least the closest to the facts we have. Let me ask you this. So it says safe, continuous, and unobstructed means of egress shall be provided from the interior of a structure to a public way. Now, it only mentions egress, and I believe, Mr. Lambert, it was ingress. Are we
That's
just
correct.
to ignore? The city
No,
didn't say anything about
Sorry to interrupt.
ingress, but
No, Your Honor, and we make that argument in our brief that, the ordinance could very well say ingress or egress. It'd be very, very easy. It chooses very specifically to use egress. And if you look at the totality of that provision, the one that counsel says is the most specific, what you'll see is it starts from the inside, and you can imagine why that is. The idea of a clear and unobstructed means of getting out, right, as a safety measure. You understand why that is. There's lighting discussed in it, and it's all interior. And so, again, 1119.0702 is inapplicable on its face. Any other questions from the court?
No, I don't think so.
Thank you very much for your time. It's good to see you all.
Thank you. All right, Mr. LaPuma, you have 4 minutes.
May it please the court. The entirety of the Birdcage's argument inherently invites that exact issue of looking at facts in their totality for a jury to determine whether or not the very nature of this hazard, this 2 to 3 inch gap at a doorwell, at a bar, in the dark.
Well, let me ask you about that last point. If this was broad daylight, would you still have the same argument that it's not open and obvious?
Yes, the same argument would still apply. It's about the nature of the hazard itself, and we know that through the recent jurisprudence handed down by this very court, where it stated it's incredibly fact-intensive. And therefore, just because he had used this area before does not necessarily mean that by its very nature, it is open and obvious as a matter of law because of that holding from McLean v. the Drinkery, from Asher v. Glenway, and that case that I cited earlier, which states specifically, in relation to an actual stairwell, Hall v. Montrose, and I quote, "Prior usage of this stairway without incident is not sufficient to charge her with knowledge of any defective condition because knowledge of the condition was not essential to the prior usage of the stairway. And here's what that means. Let's use something much more obvious. If there was a pot or a plant blocking that doorway, and walking in, Roger had to walk around it to get in the doorway, that is essential to navigate around it. There's been some conflation about normal gait. That's exactly the point. Those that are fortunate enough to ambulate pick up their feet when they walk. That's what Roger did. That's the nature of a latent defect. As also mentioned in the brief, when they took over, they being the birdcage, had an obligation to bring up the building to code. At the time of Roger's fall, they were open for a little over a year. That's exactly the point that you made, Judge Bergeron. This is a bar. You're serving patrons. In other areas of the bar, you try to make it safe, and that is exactly why everything should go to a jury to determine. Well, he should have been looking out. Well, he was drinking. But the trial court usurped the role of the jury in assessing the totality and deprived Roger of the ability to present all of that evidence and showing what a bar should do when it knows that a violative threshold exists as a primary entry and exit to a bar way. They didn't do so.
And and this threshold violated the building codes because it wasn't safe, continuous, and unobstructed.
It violated that section of the actual municipal code along with light, ventilation, occupancy. I won't go down and address every component of that, but also multiple building codes cited ranging from 1003-4 through 1003-6 and 1008-2 illumination required.
So what evidence of the lack of illumination is in the record here?
In construing the facts in light most favorable to Roger, the own general manager, Guy Ulam, testified when asked, was there any direct overhead lighting? No.
But this section that you cite, does that require direct overhead lighting?
It says 11-190492, light at all times with at least a 60-watt standard bulb or equivalent. There were some hanging light testimony, et cetera, but the whole point being these questions, if there's a tenable assertion of this, are matters for jury to assess and determine if a violation occurred.
But don't you have to put in some evidence into the record that this particular section was specifically violated?
Yes, Your Honor, directing it to Roger's testimony if there were no overhead lights or bulbs.
That's enough, you're saying?
Excuse me?
That's enough to show that they violated 111904.2?
Yes, because in viewing the light most favorable and not in favor of defense, the jury could hear that and make a determination. It's for those reasons that we request this court reverse the trial court's decision and allow this case to proceed forward. Thank you.
Thank you both for your arguments this morning. The case will be submitted. We'll get out a timely written opinion and hope you all have a great day.
Thank you.
All rise. The Court of Appeals for